Hello, colleagues. Today we have a broadcast from London together with Chair of the Bar of England and Wales, and we are going to discuss about high standard of legal profession in England and Wales. And I have the honor discuss today with Samuel, Chair of the Bar of England and Wales. So I want to ask you about a brief introduction of Bar Council and yourself and your role in Bar Council of England and Wales.
Thank you, Alexander. It's a real pleasure to be able to speak to you, the International Advocates Forum in Kharkiv. I'm delighted to be joined here from London, from the Bar Council offices here in London. My name is Sam Townend, KC, that's King's Counsel. I'm the chair of the Bar Council of England and Wales. That's the representative body of the 18,000 or so barristers of England and Wales. We are in England and Wales, we have a split legal profession. So we have the solicitors, who are represented by the Law Society of England and Wales, of whom there are about 160,000, who tend to be client-facing, deal with substantially non-contentious, non-litigation, as well as litigation work, and are able to hold client money. My members, the 18,000 or so, are the specialist advisors and representatives in court and in other disputes forums. We're the ones, if you've seen any English legal programs, we're the ones that wear the wigs and gowns that you may have seen in court. So my job as chair of the Bar Council, which is 115 strong, elected members of the bar, my job is to represent the interests of barristers to government, to ministers, civil servants, the senior judges, in the media and elsewhere. I'm also formally the regulator of barristers, but that is a matter which I'm required to delegate to another body, but I retain a supervisory role of some sort. And those are essentially the tasks. So we act in both the interests of the bar, the barristers, and we hope in the public interest in everything that we undertake.
Thank you very much. Now in Ukraine, we have a discussion about responsibility, advocates' responsibility between society and new rules and new standards for profession. And some professionals in this field ask us about English experience and top high level of requirements for barristers. Can you briefly show to us who can be barristers and which skills important for this profession in England as a golden standard of justice in the modern world?
Yes, of course. So in order to become a barrister in England and Wales, you need to have something called a qualifying law degree or the equivalent of it. So in my case, and the profession is roughly split into two. You will have, much of the profession will have taken a law degree, so a 3-year law degree in a university in England and Wales as a starting point. That would qualify as the academic training. I, in fact, studied history for my first degree, and many other barristers have also studied for their first degree different subjects. So, and then to get my qualifying law degree, I added on a 1-year diploma in law, so an academic course for 1 year postgraduate after my law degree, and that then dealt with part 1 of the necessary training. So that there's the academic training. Secondly, there is the vocational training. So this is a 1 year, typically 1 year course, although you can do it over 2 years part-time, a 1 year course where you do the vocational training. So that is mastering civil and criminal legal procedure and other aspects of practice. So for the bar, it includes things like our written statements of case called pleadings. It includes, importantly, advocacy training and training in other areas, negotiation, conferencing with clients, and so on. It includes training on ethics, ethical standards, and then also you can specialize in certain areas. Some people specialize in consumer law, some in crime, some in commercial, sale of goods, a whole host of specialist courses. And of course, we have constitutional and administrative public law requirements too. So all of those, it's a bit like being back at school for 1 year. You have to cover all of those off before you then can move to the third stage, which is called pupillage. So that's effectively a training contract for 1 year, a pupillage year. And then after you've completed your pupillage year, as well as certain other requirements, which I can talk about, doing qualifying sessions with one of the Inns of Court, you can then be a practicing barrister. So really there are 3 stages. Firstly, the academic stage, secondly, the vocational stage, thirdly, the training stage. And it's only after those 3 are completed that you can practice as a barrister in England and Wales.
Thank you very much. You talk about ethics standards. Now we have a media age, social media age, and many lawyers work maybe more than half of our time in social network and use it like media basement for practice, for discussion with public, and also as a marketplace for clients. Do you have a special requirements for barristers' behavior in social media?
We do. So the way in which the ethical background works is that our regulator, I mentioned that we delegate. I have to delegate my regulatory responsibilities to another body. That's called the Bar Standards Board. The Bar Standards Board produces a code of conduct. It's called a handbook. And that has a tier of conduct obligations, including at the apex at the top, we have 10 core duties. And then there's guidance underneath each core duty, which helps you understand how you are to conduct yourself. And core duties include, for example, you must observe your duty to the court in the administration of justice. So when we're in court, we're court officers, as well as owing duties to our clients. So, for example, an obvious example is that we must not mislead the court. Secondly, you must act in the best interest of each client. Thirdly, you must act with honesty and integrity. Fourthly, you must maintain your independence. In other words, that helps you with the tension occasionally between your interests of your client and maintaining your duties to the court to not mislead and so on. Then the 5th core duty is you must not behave in a way which is likely to diminish the trust and confidence which the public places in you or the profession. And then the 6th duty is about confidentiality. You must keep the information that you receive from your client confidential. 7th, you must do a competent job. 8th, you must not discriminate unlawfully against any person. 9th, you must be open and cooperate with the regulators, so the Bar Standards Board. And then core duty 10 is about taking reasonable steps to manage your practice competently and complying with legal and regulatory obligations. So the duties in relation to social media fall really underneath a number of those duties. So, for example, core duty 5 was you mustn't behave in a way which is likely to diminish trust and confidence the public places in you or the profession. So it wouldn't be appropriate, for example, to deride the judiciary when they're carrying out their proper functions through a series of social media posts. You mustn't personally attack through social media, or indeed incite violence or other things on a judge or on your opponent through the use of social media. Now, the regulator, the Bar Standards Board, produces its own guidance in relation to social media, and I'm sure that a link can be provided to that. And as does the Bar Council, the representative body, we fill out that guidance with our own, I hope, common sense suggestions and work. But what I accept is this is very much a moving field. So we have new social media outlets, new social media forums, and we regularly review that guidance with that in mind. But essentially it comes down to this, a common sense approach, that you wouldn't behave on social media any differently to how you would behave face to face, in person or on the telephone. And conduct that falls below the appropriate standard in person may well fall below the appropriate standard on social media.
Great, thank you. From advocates' behavior on social media, let's follow to a question for working with media and working and cooperation with government in cases, because main duty of barrister and advocates in Ukraine is to help for court to find justice. But in Ukraine, we have situation when very often when opposite side, prosecutors, police office, and sometimes court fighting against defenders, against advocate, against bar, and show to public using media and media center of prosecutor office, for example, or national police office, about advocates is partners in crime sometimes.
Yeah.
And this is very difficult question now in our society about pressing from media to bar and for all advocates. And very often we have cases when crimes against advocates just because advocates making our own job in court and became a participator and partners in crime. So what, how British society and Bar Council fighting against this? Maybe you have some instruments and some tradition against this identification barristers together with their clients.
Yeah, well, it's interesting you raised this. This has been very much, interestingly, a present issue in England and Wales over the last roughly decade. So we have what we call, the bar here has what's called the cab rank rule. And the cab rank means that we as barristers must take the next case that comes along. So for the taxi, it's the next passenger that comes along. You must do it. It's called the cab rank rule. That's part of our duties. And it fits, in fact, with the UN basic principles on the role of lawyers. And you may recall that paragraph 18, which says that lawyers shall not be identified with their clients or their clients' causes as a result of discharging their functions, as a result of being a lawyer. The issue of media and political targeting of lawyers is something that we do understand here in England and Wales. We had an incident back in 2016 where there was a decision on a case that the then government, some ministers within it, didn't like. And on the front page of our most popular newspaper was a headline, "Enemies of the People," with the pictures of the three judges who'd made the decision. Our Chief Justice Minister has a legal obligation to defend the independence of the judiciary. And the minister then, she did not stand up for them. She said nothing. And as a result, she was called Liz Truss. You may have heard of her subsequently. She became Prime Minister. But as far as lawyers are concerned, she really let lawyers and judges down. We then had a series of years when there were attacks through social media, through media, and through speeches in our parliament on lawyers. Many lawyers on whichever party were behaved extremely well and diligently, but there were some lawyers who did not and who really should have known better. So we, for example, in about a year and a half ago, one of the political parties issued a dossier attacking a solicitor who acted for immigration and asylum applicants. This solicitor was not a political activist. She was simply doing her job. Jacqueline Mackenzie, she was called, of Lee Day Solicitors. Now, the political party had issued this dossier to some right-wing newspapers who then proceeded to attack in their media outlets. That kind of behaviour is completely unacceptable, and the Law Society and the Bar Council stood with Jacqueline and her law firm to deprecate, to criticise that conduct. In the run-up to the last election, we also had regular attacks on the Keir Starmer, who is now the Prime Minister, when he was leader of the opposition, in relation to some instructions he had taken about 25, 30 years ago when a practicing lawyer. Those criticisms were to the effect that he was, as you said, Alexander, enabling or partners in crime. But it was a complete misunderstanding and a deliberate misunderstanding of how the conduct of lawyers is to take place. So we criticise that, and since the election, I must say, things have greatly improved on that. We now have a senior lawyer as our Prime Minister. The new Attorney General is very big on the issue of rule of law. And so I think we've turned a page, but it is something that we all have to be vigilant about, and we have to fight back. Now, there is one other side to this issue, which is that we as lawyers must not ourselves identify too much with the causes or character of our clients. So if we're to want the protection of the UN principles of our code of conduct here in England and Wales, the cab rank rule, we also must live by that. So I'll give you an example. It is no good for an English barrister to say, I will never act to prosecute climate change protesters, for example. Because once you say that, you can say what you like in your personal capacity, but in your professional capacity, you must not, if you say that I can't keep my independence and therefore cannot prosecute climate change protesters, then you equally don't have the independence to enable you to act to defend those climate change protesters, because you've lost your professional independence. So the other side of the coin is we must not, as lawyers, associate too closely with the causes or character of their clients. We are, if you like, ministers of justice, and we need to, in our professional capacity, step away from those sorts of matters if we want the protection that these ethical codes give us.
Thank you. Thank you for a good example about different sides of coins of independence. Because independence of barristers and advocates, it's not just independence from government. Yeah. It's also independence in your opinion and your behavior, in your personal and public life. And I'm very happy to listen about new page and that new Prime Minister, professional lawyer, yes, and understand what is rule of law and justice system. And in Ukraine, we need study your experience. And my next question about education, barristers education about every year program, yeah. Because in Ukraine we have now discussion because we changed rules between 10 hours and 15 hours, yes. Annual qualify and additional qualify lessons. So do you have similar system or not? And how barristers send reports about this to Bar Council or not reports? It's free from obligation, or maybe you have some special rules for this or special bodies for this also. So,
yeah. Thank you. Number of points arise. The continuing training, continuing professional development, we call it, is really split into two types. There's the first, the new practitioner program, which is during the first 3 years of practice, and then the established practitioner program, which is thereafter. The new practitioner program includes some particular requirements, such as, for example, accountancy, being able to manage your practice, some ethical issues which form part of that first program. And it's a little more intensive in terms of obligations and time than the established practitioner program. The established practitioner course, we've moved away from a fixed number of hours, and we've moved to a system where you each year plan your CPD, your continuing professional development program. You then carry it out, and then you have to write a report reflecting upon the previous year and what you might need to change for the following year. I think, to be honest, there are two ways of looking at this. I quite like, actually, and I think much of my bar likes the system that you have, which is a 10-hour or 15-hour requirement. The downside of it is that could be seen as a box ticking exercise, if you know what I mean by that. Something you go through the motions, then you collect the hours, and then you don't think about it anymore. And this new scheme that we have, it's about 10 years old now, is supposed to be different to that. On the other hand, I have a number of practitioners that perhaps don't do much continuing professional development at all, and having this new self-reflective, as they call it, scheme allows them to get away with doing perhaps less than they were doing before. So I think there's a debate to be had, actually, about what's the best system. Something of a live debate at the moment at the English bar. But you've moved from 10 hours to 15 hours.
Yeah.
Is that with the aim of bringing in particular requirements, or?
It's application requirements, and now from last Friday, because new decision of Ukrainian Bar Council last Friday about change from 1st January for 15 hours. And it's interesting for me because I'm working as a support Kyiv region advocates for these webinars and this lecture, and we need to share experience and find lectures for different area of law.
I see.
For minimum 40, 50 hours every year, but to give advocates choice of training.
Yeah. In terms of the choices of training, there's quite a wide range of choices. We at the Bar Council provide certain continuing professional development programs that you can take part in. Some across the bar, we have specialist bar associations and other organizations that provide these sorts of courses substantially for free. Some require a modest cost, but on the whole, it's not very costly. In terms of the supervision of the schemes, that is done again by the Bar Standards Board, the regulator, and they ultimately can call in an individual to ask to see their records of the continuing professional development that they've been doing over the last year or several years. But they do that on a spot check basis. So it's relatively infrequent. For example, I'm now, was called in 1999, 25 years in, and I've never had to evidence my continuing professional development. But it does happen. It does happen.
So in England, you have one body for certification or for some agrees with courses, with standards, because in Ukraine now we have some discussion about some few universities have possibility to organize similar courses, but Bar Council asked about certification all process in High School of Advocacy.
Yeah.
Do you have similar systems here?
So anyone can provide the courses, but they will ultimately be supervised by the Bar Standards Board. Of course, the solicitors have a different scheme, and they're supervised by the Solicitors Regulatory Authority. So in that sense, we have more than one, but for barristers, ultimately, the continuing professional development will be supervised by the Bar Standards Board.
Great. My question next, and maybe last question, about your personal view for future challenges for advocates and barristers.
Yes.
Using modern technology gap between old style lawyers with code, with papers, and artificial intellects, and blockchain technologies, and also online broadcast, court hearing, Britain very development on the technology development country, and Ukraine also technology development. For example, now we're using digital court system, and I can work from all planet, and Ukrainian judges use this system same like common civil or criminal procedure. And your opinion about challenges and special requirements for barristers in this age?
Yeah. Wow, that's a very substantial question, Alexander. I think myself that the future for barristers in Ukraine, in England and Wales and elsewhere is bright. So we still have a growing profession here in England and Wales. The developments, for example, in relation to IT and AI in particular, are obviously something that we need to pay careful regard to. And we put out, at the very beginning of this year, in fact, we put out some advice to our members on some of the challenges and difficulties that are posed by the use of AI in practice. I think, however, the skilled work of lawyers, whether it's on advice, whether it's on representation, analysis, and so on, AI and these other tools will be an aid to that, but they aren't going to replace lawyers. I don't think we're going to be in that territory. I think some of the more mundane aspects of being a lawyer, such as, for example, review of disclosure, review of documents, the tech is there to make that more efficient. We mustn't forget, though, that the tech is very energy intensive and not very, these data centers are not very globally sympathetic. They're not very green. So I think we'll only get you so far, but also I would think that rule of law requires not just a resolution, a determination. It's as much as anything about the process of getting there. The human factor, I suppose you could call it, of dispute resolution. Obviously, I'm speaking mainly from a litigation perspective or disputes perspective. The key is going to be, does the party that's lost, whether that's someone in a criminal case that's going to be imprisoned, whether it's a losing party in a commercial dispute about the proper meaning of a contract, do they accept the result? And that means, do they feel, have they had a fair crack of the whip, as we say? Have they had a fair hearing? Have they been heard by the judge or tribunal? And do they understand and accept why they've lost? And I think that you can't automate justice in that way. You need, it's as much about the process of getting there and having buy-in ultimately from the losing party. And that's where you see, I think, the bar here and the bar in Ukraine will always have a role. People are going to lose their liberty. They're not going to accept an algorithm telling them that. They're going to need a process where they are able to have their voice heard. And then there's a determination which has a democratic component to it against them before they will accept that the state has made a decision that they should be in prison, or whatever the particular scenario should be. So I think the future's bright for lawyers. I think we stand up for justice collectively. That doesn't mean that we are campaigners or signaling virtue or anything like that, but we are there to help administer the law, administer how we are to behave against one another, whether that's in commercial or criminal, family, or whatever other disputes. I think we still play an essential role in creating or maintaining the rule of law.
Thank you. Thank you, Samuel, for your lecture for us, for your experience, and you show to us of maybe future steps and our ways for better justice in Ukraine using English experience and Bar Council standards, of course. Thank you very much.
Can I just say one thing?
Yeah.
I want to thank you, Alexander, for the work that you do in promoting Ukraine here in England and Wales. We know England and Wales stands side by side, and the lawyers stand side by side with lawyers in your country. You're going through an immensely difficult time. We've done quite a lot of work together, I think, in terms of housing lawyers that have been dispossessed from homes in Ukraine. We've helped a number of my colleagues do enormous work to try and assist Ukraine. And this is part of a hopefully continuing program with the Ukrainian Legal Bridge a new initiative we're starting off in conjunction with our Ministry of Justice, when we're looking at things like capacity building and so on. And I must say a small credit to the last Attorney General, Victoria Prentice, King's Counsel, who has done enormous work and continues to do enormous work in training of both prosecution and defence counsel. I mean, there's a lot more that can be done, but I'm sort of proud that we have been doing some good work, and I want to ensure that work continues. but I also wanted to thank you, Alexander.
Thank you. Thank you for you. Thank you for your support, and all barristers of England and Wales who support Ukrainians, and all British people who honestly stay together with us in this difficult time. But we will win together. Thank you very much.
Thank you.